Hello everyone, my name is Vrinda Bhandarkar. I am a student of S.D.M Law College, and in this video we will be dealing with the concept of criminal misappropriation of property. It has been comprehensively dealt with under sections 403 and 404 of IPC 1860. Let's just imagine your friend named A takes away a book from your library under the wrongful belief that A has implied consent from you to take that book away. After some point of time, after the passage of a certain period of time, A comes to the knowledge that they did not have the implied consent from the owner of the book, that is you. Now the right behavior from that of A should have been the returning of the book back to you. But A does not do so. Instead, A takes that book and he sells it to a second-hand bookstore and takes money instead of the book. Is this an offense? What should have been the rightful behavior of A? If it's an offense, what is the punishment prescribed for it? Is it theft, or is it a very different offense from that? And if it's different, why is it different? So let's understand the answers to all these questions through this brief video on criminal misappropriation of property. So under section 403 of IPC, both the meaning or the definition of criminal misappropriation of property as well as punishment has been specifically laid down. Let's first understand what are the ingredients that are required in order to constitute the offense of criminal misappropriation of property. The first ingredient is that the property which is the subject matter of criminal misappropriation of property must belong to or some other person apart from that of the accused must be the owner of that particular property. The second ingredient is that the accused must have misappropriated or converted the property for his own use. The third ingredient is the mens rea element or the mental intention of the offender, that is, the offender must have acted so with a dishonest intention. Dishonest intention is defined under section 24 of IPC as causing either wrongful gain or wrongful loss. Therefore, this constitutes the mens rea element in this offense. Therefore, if the person has been acting in good faith, it does not come into picture. Another point regarding this is that the subject matter of criminal misappropriation of property is always a movable property. It cannot be an immovable property. Therefore, criminal misappropriation of property can be that of documents or jewels, but it cannot be that of land or a building because it's an immovable property, whereas the subject matter of criminal misappropriation is only a movable property. Furthermore, let us understand how does criminal misappropriation of property actually take place. In case of criminal misappropriation of property, a person or the offender in this case comes into possession of that property innocently, but there is a subsequent change in his intention, or he or she gets acquainted with a fact with which that particular offender was not acquainted prior, after which there is a change in intention, that is, there is emergence of dishonest intention, and thus the person later converts or misappropriates the property for his own use. Also, criminal misappropriation of property is not constituted when a person takes into custody or his possession certain goods in order to protect them or in order to restore them to the real owner with bona fide faith. However, if a person, upon knowing who the owner of the property is, still holds the property, then the possession of such property by that person becomes wrongful or fraudulent. The person must take reasonable means in order to discover who the owner is and to restore that particular property to the owner, and must also provide a reasonable period of time for the rightful owner to get into possession of that particular property. If that is not maintained, it will result in the offence of criminal misappropriation of property. In Gadagaya versus Purna Siddheshwar, the idol or the deity of a temple which was supposed to be kept with the temple for worship was used for purposes other than that. In this case, it was held that there was criminal misappropriation of property. The punishment that is prescribed for criminal misappropriation of property is imprisonment of 2 years or fine or both. Under section 404 of IPC, criminal misappropriation of property of a deceased person has been dealt with. Here, if a person misappropriates the property of a person who has died or deceased is dealt with. In such cases, the person who commits such kind of criminal misappropriation is liable to undergo imprisonment of 3 years or fine or both. If, however, the person who criminally misappropriates that particular property was employed by the deceased, then, for example, if he is a clerk or servant of the deceased, in that case, that servant or clerk who misappropriates the property will be liable to undergo an imprisonment period of 7 years and shall also be made liable to pay fines. For example, A, who is the servant of Z, on the death of Z, takes away certain furniture which belongs to Z and for which the rightful heir was H, and he misappropriates it by selling the furniture to a second-hand goods seller. In this case, A is held liable for criminal misappropriation of property of the deceased person, and he shall be liable to undergo an imprisonment period of 7 years upon conviction. Thank you very much for watching this video. Happy learning.